One. Just about. Good morning.
Sound check.
Yep, good morning everyone. Welcome. Thank you for joining us on a cold London day in our very lovely surroundings here. I look well out of place. I came up this morning and thought, God, everyone's dressed up and I look awful. So forgive me for the way I appear. So thank you for coming to this Workable GDPR Live event. My name is Matt Buckland. I'm the Vice President of Customer Advocacy for Workable. We're excited to be here. We've got about 70, 80 people in the room, but we do have around 2,000 people watching on a live stream. So with that size audience, there are some house rules. If you are going to get up and walk around in front of the camera, do give them a wave. I mean, try not to walk in front of the camera. That would be great. Similarly, if, like me, you've left your mobile phone on, please switch it off. Good. This is a Q&A session, so it is designed to be interactive, to get you the answers you want. So in between the slides, we're going to have questions there. We're going to take one or two questions after each point of Carol's presentation. We have Whitney and Erin, our roving microphone, so do wait for that so that people who are watching on the live stream can hear us as well. So I have to read this bit, very sensible. The EU-mandated General Data Protection Regulation goes into effect on the 25th of May, 2018. It's going to change the way everyone here handles data, and in particular for what you guys do and what I used to do in HR and recruitment. So we're here today to try and break it down, to demystify it a little bit, and see how it pertains to our actual use cases, so that you can ask questions around like, can I do this? What if I do this? We're very lucky, as I said. This is Carol Umhoefer. She's the partner and co-chair of the EMEA Data Protection, Privacy and Security practice at DLA Piper, who are known around the world for their legal expertise. I'm going to hand you over to Carol now to get started. Carol.
Great. Thanks very much, Matt. Thank you, everybody, for being here today. So, what does GDPR mean to you?
My bit.
Cue Matt.
Not cue me. Not me at all. It's not me being silly, is it?
Okay.
Ah, there we go.
Okay, great. What is GDPR? I'm sure all of you can answer this question, so bear with me for the few people who maybe have not heard of GDPR or need a little bit of a review of its principal effects. So GDPR is about reinforcing data protection. It's also about harmonization of data protection laws across the EU. So the idea is that there's one regulation across all 28 member states. There's still 28 member states for a little while yet, yes. It will apply from May of this year. We've been talking about GDPR for years and years, but yes, it's finally upon us in about 4 months. GDPR will officially apply. And the idea is to harmonize data protection laws. So you hear a lot about this. The interesting thing is that for you professionals in recruitment and HR, the harmonization is somewhat limited, and for several reasons. Why? Because first of all, there is a pretty large derogation for member states to legislate around employee data processing. And member states have already begun to use that facility to indeed legislate on a national level. There are also exceptions that relate to the processing of criminal records data and special categories of data, otherwise known as health data, trade, union records, and those types of things. And so there again, member states can legislate, which means that invariably, and nobody likes to hear this, national law remains really important. And some of you certainly know this, but for example, the new German data protection law, which has already been approved, has continued the existing regime for protection of employee data, which means that already Germany is positioning itself differently from other member states. So it's not going to be this world of one law across all of the EU. You're still really going to need to pay attention to the national laws, and of course not only data protection laws, but employment laws and labor laws. Those are all going to be very important. And last but not least, everybody knows this because it gets a lot of attention, is that GDPR brings with it, for the first time, the possibility of massive financial penalties. Here again, it's important to stress, those penalties will be assessed by national, or sometimes even state in Germany, regulators, data protection authorities. So yes, there is harmonization, but the role of the national and state data protection authorities is going to remain really significant, because they're the ones who can ultimately decide if there's going to be a sanction or not. GDPR and the data life cycle. So this next slide.
I'm letting the slide down quite badly. Sorry.
Yes. OK. Now, we're actually not going to talk about most of this today, but before we get into the issues really specific to your profession in HR and recruitment, I just wanted to kind of show an overall big picture view of what GDPR means. And that is, GDPR affects the entire data lifecycle. And before the data even exists, you should be thinking about GDPR. This slide summarizes some of the principal, or most of the principal issues you're going to be looking at under GDPR throughout the entire data lifecycle. And even before you collect the data, planning to collect and process data, right? You're consulting your DPO. You're looking at your privacy by design policy. You're conducting a DPIA, also known as a data protection impact assessment. You're thinking about data minimization. You're thinking about what is the legal basis for collecting this data. All of that you should be doing before you even start collecting the data. And then when you collect the data, there's new notice requirements. You know this. You might be asking for consent. We'll get into details about that later. You might have contract terms that are adapted to the new world of GDPR when you're collecting data. Data use, sharing. How are you dealing with third parties with whom you're sharing data? How are you handling the data subject rights? And then the big issue of data reuse. Wow, I have all this recruitment. This talent pool, and now I want to start marketing to these people. How do I reuse that data? Can I reuse data if I anonymize it? And then at the end of the data's life, am I getting rid of it, or am I anonymizing it, or maybe I'm just retaining it because I've got another reason for doing so. So we won't get into all this because we don't have enough time. Unless you have specific questions, happy to answer them. But it's very important, again, to keep in mind GDPR covers all of this. So moving on. And really focusing on GDPR and the implications for you. So this is really just to point out some of the key impacts of GDPR on HR and recruitment professionals. We won't be talking about all of these in depth, but there were a few. The first three I just did want to mention. One of them is accountability. You've all heard of this, right? So thinking back to that data life cycle, one thing that is really new with GDPR is the idea that you are going to be accountable for demonstrating compliance throughout the data life cycle. That means having documentary evidence of your compliance and continuous improvement, right? So I've heard it said, it's a great saying, compliance is a path, it's a goal, but it's not a destination that one ever reaches. It's never done. That's great news for all of us in the compliance world, right? Our job is never done. But you're seeking continuous improvement. You've got your policies, you're auditing compliance, and you're improving as you move along. So accountability is very important, because what we see in practice a lot of times is that what people are doing operationally in an organization is the right thing to do, and they can't really prove that they're doing it. It's better to have a policy going forward to meet the accountability requirement under GDPR. Something else that's really new for HR and recruitment, depending on which country you're sitting in, is the idea that you have to notify a data breach, not only to regulators, but in some cases also to the data subjects. So unless, for example, you're working in the Netherlands where there's already a national law requiring data breach notification in some cases, this is new. You might, for the first time, be faced with the obligation to let candidates know that, hey, guess what? There's been a breach and your data's been stolen. Because GDPR now has a general data breach notification requirement. And I did mention this already, but particularly important in markets like the UK, where background checks are quite common, is the prohibition on criminal records processing. GDPR says you cannot process criminal records, and sometimes that has a pretty broad definition, so even allegations of criminal conduct could fall under that prohibition. But member states are allowed to legislate. The UK, there's a bill that provides an exception to allow background checks in certain circumstances. I understand from my colleagues here in the UK that that exception is somewhat narrower, or could be narrower than what you're used to dealing with, but that's an important change. So 3 topics we'll be diving into a little bit more deeply. The scope of application of GDPR. GDPR applies more broadly than the current data protection laws, and we'll talk about that in a little bit more detail. Something else to keep in mind is that GDPR will mean that there are more stringent requirements for obtaining valid consent. And for those of you who are reliant on consent for a lot of your processing activities, you'll have to rethink that if you haven't already. And then last but not least, enhanced rights and new rights for candidates and for employees, such as portability, the right to be forgotten. I don't know about you, but we as lawyers get a lot of questions about the right to be forgotten. There's a lot of panic we perceive in the market about, oh my gosh, now we have to erase all of our employees' data. How are we going to do that? Because we've been retaining everything forever. Okay. Before we move on, are there any questions?
Just a couple now.
Hi, Stuart from CIS Security. We hold criminal records checks on our filing system, and it says it's prohibited for criminal records, but we kind of require that to put officers onto client sites. How would that work?
Well, the idea is that there is this prohibition, but there can be laws that derogate from that, and certainly there are and will be laws that derogate. So you're going to have to look again at a national level to determine to what extent you can hold criminal records in any given situation. Some countries, maybe this might come to a surprise, as a surprise to some of you, but there has always been a prohibition on criminal records checks, sometimes with a very, very narrow exception. So while conceptually this is really new for the UK, for other countries this is just continuation of existing law. There's this fear that somehow GDPR trumps all. No, there are a number of exceptions for obligations that exist under other laws in a particular member state. So no panic, but it's possible that if, for example, you routinely screen all candidates for all positions, that you may have to change that practice, because the new exceptions to the prohibition could be narrower. So, any other question before we move on?
Hi, I'm Rachel from And Digital. I just wondered whether or not this will impact how we request employment references and how employees will provide references to us for candidates we'd like to hire.
Are you thinking in terms of people's own perception or of how they give out references? They're voluntarily sharing that information. Hopefully you're being really transparent about what you're doing with that information. It's really a different level from, let's say, criminal background checks, which oftentimes you actually, if you can, in some countries you can't, but you want to conduct them without necessarily informing the person, right? So that's different. I think some of the impact we're going to see in terms of references is going back to the issue of retention and how long are you keeping the references, and also how long, and we'll get into this in more detail, how long are you keeping, for example, a candidate's application, and how long are you keeping the independently sourced information in your systems. We'll probably go on, move on. So how do I know if GDPR applies? Now, for many of you in the room, that's going to be a really obvious answer. There's going to be a really obvious answer because it's like, I know, because I know. There we go. There are 3 grounds for application of GDPR. So even if you're sitting here, in the UK and you're working in the UK with UK candidates and UK employees, you might be getting questions. For example, if you work in a multinational from colleagues in, Singapore or the US or whatever, it's like, oh my gosh, what do we need to do with GDPR? And so keeping in mind that there are 3 grounds for application of GDPR. The first is the most straightforward for the people in the room, which is processing of personal data in the context of activities of a processor or controller established in the EU. So, easy example, Japanese bank with branches all over the world, including a branch in the UK. You work for the UK branch. You are hiring people in the UK for positions in the UK. Pretty obvious that GDPR applies there. That's not a tough one. Or another example, French company, US parent, has an HRIS system that it's outsourcing to a provider with servers in India. So obviously the French subsidiary is subject to GDPR, the US parent maybe. But the processing in India, absolutely. That has to be done in compliance with GDPR. That processing is in connection with the activities of a French entity established in the EU. Then there are 2 other cases that specifically apply to controllers and processors that are not in the EU, and this may be relevant for you. First of all, is processing of personal data in relation to the offer of goods and services to EU residents. So this applies even if the controller or processor is not in the EU. So imagine your UK recruitment firm, you're receiving CVs from a US recruitment firm that is targeting candidates in the EU. Okay, while you're sitting in the UK, maybe you're not so concerned with what the US recruitment firm is doing, but you should keep in mind, if they're targeting EU residents in offering of services, then they're subject to GDPR. And so you might be concerned about how it is that they are obtaining the CVs of persons in the EU. And then the third ground for applying GDPR is monitoring behavior of persons in the EU. Those are EU residents, not just people who are coming to vacation for a week in London. So think of a US employer that is tracking its EU candidates, perhaps tracking location, browsing preferences. They can do all this through their website, possibly through an app, and then transfers it to its UK recruitment firm. Again, sitting in the UK, you might not be so concerned, but you should perhaps be aware that this tracking behavior is actually subject to GDPR. And think about maybe contract terms, as between you and the US employer, and how it is that they're complying with GDPR. Do we have any questions on that? Sure.
A couple.
Hi, I'm Georgiana from Paddle.
Hi.
I have a question. So what about if you are a US subsidiary of a UK company and you process data for US citizens as opposed to just EU citizens? So you only have to be compliant if you process data for EU citizens or also for US citizens?
So generally speaking, just a first comment, the GDPR does not refer to citizenship as being a criterion for application. It talks about persons in the EU, which we're interpreting as EU residents. So US citizens and US residents, the intention is not to protect them. You can very well have the case of a US citizen relocated to the EU and residing in the EU. And as a general rule, then GDPR would apply because the intent is to protect the personal data of those individuals. One way to look at it is that there are a number of consumer law aspects to GDPR, which is really a big change. The rules for application right now of the data protection laws are a bit unique, to say the least, because you're really only looking at where the data controller is established, right? The idea behind GDPR is to protect e-residents' personal data. So right there, conceptually, that's a big change and broader application of GDPR. Gonna move on?
Yep. I can. Let's try.
So, what about consent? What about consent? So,
Consent.
consent. This is one of the few areas where consent is actually a bad thing. Think about that.
Wow.
So, consent really poses challenges under GDPR, and maybe I am preaching to the converted, but we still see in practice a lot of clients come to us and they're like, oh yeah, great, we've got everything ready for GDPR. We know we're going to be sending all our consents out. We're getting everybody to re-consent, and on and on. You should, if you're still relying on consent, you're thinking about getting consent, you should probably rethink that if you haven't already under GDPR. Consent is really going to pose more and more challenges under GDPR. So, and for many reasons. And one of them is that GDPR says that consent can't be valid if there's an imbalance between the controller and the data subject. And although the exact example of the employer and the employee isn't given in the recitals of GDPR, this is understood to be the case, right? There are already many countries where the presumption is an employee cannot validly consent to the employer except in very unusual circumstances. So one manifestation of that is to get consent at the time somebody is hired, the thinking being, well, the person is not yet an employee, so the consent will be valid. Whether or not the regulators agree with that remains to be seen. But even leaving aside the idea that employee consent is inherently very problematic, there's the fact that there are these requirements around consent, which exist to a certain degree today, but GDPR puts more of a focus on, and we expect that the regulators will be paying far more attention. First of all, the idea that consent must be freely given. So again, if there's an imbalance, you can't have free consent. One of the manifestations of this is the idea that you can't be trading consent for something else. So one of the things we talked about is, okay, so somebody's applying for a job, I am going to get them also to consent to keeping their candidacy, their application forever for whatever period of time. So you can really question whether or not that's freely given, because you're in a way conditioning the application for the job on obtaining consent to keep the person's application for a long time. You can't link consent to anything else. It truly has to be freely given. And it has to be specific, so no more broad consents. It will have to be specific, let's say, to the recruitment process. We don't know exactly how to interpret this yet, but you could even say, does it have to be specific to a recruitment process for one job application? Well, probably not, based on the existing regulator guidance, but it does need to be specific. And it needs to be informed. And in practice, this means two things. Not only are you providing the beautiful Article 13 or Article 14 notice, which, as you know, requires a lot of information and new information, but you're also giving information right there at the point of obtaining consent. So next to the checkbox or whatever it is, you're providing very specific information, which is somewhat redundant with what is in your notice. And then you need unambiguous consent. So interestingly enough, today, in some member states, the laws actually don't require explicit consent. Implicit consent is valid. The regulators have been trying to roll this back, saying, oh, well, you can't presume consent by a lack of action. But GDPR makes it very clear, you need an affirmative action to get consent. So you can't send out information to somebody and say, oh, and by the way, if we don't hear back from you in 30 days, we're going to presume that you have consented. That won't fly. Consent has to be withdrawn as easily as it was obtained. So you shouldn't be making withdrawal of consent subject to a 5-step process when opting in the first place was a one-step process. And then there's the issue that under GDPR, rights are, to a certain degree, that is, the rights of candidates and employees are tied to the legal basis for which data is processed. So consent is only one of, depending on how you count, like 10 legal bases for processing personal data. So you do have options. But if you are relying on consent, people have more rights. It's logical, right? If you're relying on the fact that you have a legal obligation, different law, let's say, that requires you to collect criminal records data, there are many fewer rights of the individual in respect to that data because you're collecting it to, in fact, comply with EU law. Whereas if you're relying on consent, people have many more rights in respect to their data. So something really to think about. And we're going to be focusing on, we're looking at all the rights, but in particular, right to be forgotten, right to erasure, same thing, portability. There we might have some questions.
I think we probably will. So I have a question.
Good.
Can I ask a question?
Softball.
On particular consent, a lot of the people in this room are going to be reaching out to candidates for jobs. Those candidates, they may have obtained their email addresses, that sort of stuff, from public data. Do I have to send them an email asking for consent to then send them another email? Or is that a legitimate interest? You knew this was coming. You knew this was coming.
Okay, so like I said, there are so many conditions you have to satisfy to lawfully process personal data. And there are different categories of conditions. And one of them, a very important one, is the legal basis, right? It's the justification that you must have for processing personal data. And among those legal bases, there's consent, there's compliance with laws, EU laws. There's performance of a contract, taking pre-contractual steps at the request of the individual. Interesting.
Yeah.
You're thinking about the person wants to enter into an employment contract with you.
Yep.
They're trying to do that, so processing their job application can be seen as taking a pre-contractual step. There's also legitimate interests. And this is an alternative to consent, right? And basically what GDPR says, and this is similar to existing law, you can, for a legitimate interest, not a legitimate business interest, a legitimate interest, process personal data, but you have to conduct a balancing test with the rights of the individual. So you're basically saying, do our legitimate interests here outweigh the rights of the individual? And depending on the circumstances, I think it's completely plausible that you would say, yeah, we have a legitimate interest here. Now, we have to, otherwise comply with all the requirements of GDPR, including notice, and very detailed notice. And when you're not collecting data from the person, you're getting data about a person from another source. There are specific requirements. It's Article 14. And within 1 month of collecting the data, you have to inform the person whether or not you need to obtain, well, that'll be another question. Let's just stop there.
So I've taken the lion's share of that question, but does anyone else here have a question?
Hi, my name's Connor Chapman with DealCloud. So the first question that I have is, how does GDPR relate to legacy databases? So is this a go-forward basis for data, or is this a retroactive as well, looking at previous contexts that you've collected over time?
Yeah, so GDPR applies as from May 25, right? It applies to all processing at that date. So if you have data that's archived, collected 10 years ago, that's still archived and still existing on May 25, GDPR applies. Remember, GDPR actually took effect in April of 2016. You've already been given 2 years to come into compliance.
First I've heard of it.
I mean, we first started talking about this in 2009, so arguably there's been even
We're late to the party.
longer time. So yeah, absolutely,
catching
it
up.
applies. And I think this comes up over and over again. You can tell by the accent I'm American, right? The fact is no, I didn't fool you. Fact is I practiced in France for over 20 years. And so I'm a French lawyer and EU data protection practitioner. I've really noticed a difference between the tendency in Europe to keep data a long time. Not that it doesn't happen in the US, but there's a little more pressure for other reasons to get rid of data. In the US, this is something that, and even within the same organization, we see it all the time. The US subsidiaries have been cleaning up, every decade or so, and getting rid of legacy data. And whereas maybe the EU affiliates, wow, we still have, all our data since the origin of time. So yeah, absolutely, it applies. All that legacy data.
One more. So on May 25th, May 26th, basically whenever GDPR goes into effect, if the company is taking the consent route and not the legal, trying to get around the laws using the EU laws, are we as individuals going to get an inflood of emails from companies asking for our consent to hold our contact information?
Not necessarily. There really is a lot of consideration being given to whether or not consent is truly required. Okay? And even if you get consent, is it valid? And so it is absolutely plausible and defendable from a legal point of view to say, wow, we collected data originally on the basis of consent. We no longer need to rely on consent. We're not going to rely on consent. However, in our notice, we're explaining the legal bases on which we're relying. It's no longer consent, maybe it's pre-contractual steps, maybe it's legitimate interest, something else. So that will be transparent to individuals.
Thank you.
Again, you can tell I'm really down on consent when it comes to data protection, so.
I think there's a kind of security blanket for recruiters in particular about having a big database of candidates. We think it's good, but I think our advice would be to keep that data fresh and know when that's getting stale. I think we're going to come on to that sort of stuff as well, but to have sort of candidate databases which go back years, and then everyone's changing jobs in 13.5 months in the tech space at the moment. So how fresh is that data? Exactly.
And it goes to, this is where business interests really align with the law, we like to say, just because data quality is really important. And it's also reflected in the principle that you're not keeping data for any longer than the purposes for which you collected it. So then getting back to an earlier statement, did you collect it for one job position? Or did you collect it in order to keep somebody in your talent pool? So.
Yeah, so despite it feeling good and keeping you warm at night, all that lovely data, it's not going to be useful, so maybe delete it.
Absolutely. So what are candidates' employees' rights? What are we doing on time here, too? Okay. So RTBF, everybody's heard of this, right? Can we do a little poll? Honestly, how many people have someone in the organization panicked about this? Anybody? No? Nobody's panicked? Really? Okay. All right. Well, I'm glad to hear that. We get so many anguished inquiries from clients, in particularly in the sphere of HR, about this right to erasure. The general comment would be, and since nobody's worried about it, I guess we'll go through this slide more quickly. Okay. But so we've listed out a few of the elements to RTBF. It's important to keep in mind there are many conditions around this right to erase one's data. So you have to meet certain conditions for the right to lie, and then there are exceptions, and they're big exceptions. So just to hammer on a theme, one of the conditions under which data may need to be erased is if consent is withdrawn. So again, you're relying on consent, and the person has the right to withdraw consent, and then what are you going to rely on to process personal data? Because you have to have a legal basis. Legitimate interests. This is your favorite, Matt. This is a weakness with legitimate interests. If you're processing on the basis of legitimate interests, the employee or the candidate can object to that processing. Doesn't mean you automatically delete the data. But then you have to go back and say, okay, now we have an objection to our processing on the basis of legitimate interests. Do we really have compelling legitimate grounds to continue processing that data? So it's like an enhanced balancing test. Obviously, if data is unlawfully processed, you have to erase it, or if erasure is mandated by EU law. But there's some important exceptions to the right to erasure. One of them is if EU law requires retention, and another is to establish, exercise, or defend legal claims. So what's interesting here is the different positions that have been taken on what it means to have to keep data, not erase data, to establish a legal claim. In some markets, there's kind of a general approach that as long as a statute of limitations has not expired, it's justified to keep the data. So now, push that, which makes sense, right? You don't know today. You might get a claim in 3 months, 3 years. The statute of limitations is running for quite a while. How this plays out is really going to be case by case. So for example, if you look at a discrimination claim, discrimination in hiring, if the statute of limitations is 20 years, are you really going to be keeping the applicant's data for 20 years on the theory that a claim could be filed up until the end of the expiration of that statute of limitations? This argument doesn't fly in some countries. For example, in Germany, my colleagues tell me some regulators have taken the position that you actually need an indication that there is a dispute, that there could likely be a legal claim in order to use this justification to keep the data. Any questions on right to be forgotten?
We all seem remarkably chilled out about right to be forgotten. On that, if we have, so one of the cases I could see it coming up is if you contact a candidate, hey, do you want to come and work for my company? He says, no, I hate your company, delete my data. Would that then affect other approaches that you would make with other people? Should you consider those? Or would you just go, okay, he's crazy, I won't keep his data?
I won't keep his data.
Yeah. No, because what's the point, right? He doesn't want to work for you.
Absolutely. You know, when it comes down to, you can really get into trouble, obviously, because of one person, right? We had a case in the UK a few years ago in recruitment where one candidate for a job application got a little bit upset with the recruitment methods at our client and went to the ICO. And the ICO arrived. Yeah. Now, admittedly, the recruitment method was a little bit innovative. It wasn't, well, there was a borderline creepiness aspect to it.
That's just recruitment, sure. We're safe here. We're
not involving some apps you might be thinking about. No, this was a few years ago. But no, but the larger point is, it only took one person unhappy with, I don't want to overstate it, because from a data protection lawyer's perspective, it was like, shocking, how could anybody in recruitment ever have thought of doing this? But from a layperson's point of view, you know, it wasn't creepy. But somebody was upset and went to the ICO, and that triggered, you know, a lot of angst, which in the end there was no fine or anything, but still, that's the point. Listen to individuals, because as I said, the sanctions are still going to be coming from the national regulators. That's not going to change. The same thing that's triggering today an action by a regulator is going to be the same tomorrow.
I think the objections I've got there are, how did you get this email? That kind of thing, because they haven't realized it's public domain somewhere.
Yeah.
And because crowds like this, we're good at finding those things, that's where they tend to object, so it feels.
Yeah.
In those cases, I've normally gone back and said where I found the email address, so that they can delete it from there as well. So I'm normally assuaged any bad feeling.
I think is transparency, and who knows, maybe your conduct, they're going to start changing their mind about the company, and you know,
because I'm so lovely.
Yeah, exactly. You're wonderful. Yeah. I would just say that because the issue does come up often, right? We're getting information from public sources. Be careful with public sources, right? So if you read the latest from the EU Data Protection Authorities, the Article 29 Working Party, they issued guidelines this past summer, updated guidelines on processing personal data at work. I encourage you to read them. They talk about, you know, using information from social media.
Interesting.
It's not perfectly clear what their position is on using. The position seems to imply once you have a job candidate, yes, you can look on social media to get information if it's relevant to the position. So there's some interpretation around there. But what I would caution you about is in some countries, again, I keep hammering this, but the approaches really are different. There are cultural differences, there are legal differences, all that. So for example, in France, there have been cases where scraping or crawling has actually led to sanctions. Why? Because, among other things, it was considered that a person who put information, publicly on a Facebook page wasn't given notice that it would be reused by a third party for a specific purpose. Wow. So you do want to be careful. I think the specific circumstances matter a lot. What's the position you're recruiting for? Is this top management, or is this we're going out and looking for 3,000 people to?
I think that's going to affect the sourcing community quite a lot because they tend to I'm going to say they like I don't do it. I'm going to distance myself. They, evil people, do terrible things like they might use a site which isn't recruitment related. So I could understand someone on LinkedIn. I'm going to get talked at by, here's a job, that kind of stuff. That's LinkedIn.
Right.
Facebook, a little stranger.
Yep.
Tinder, we're going there. I've heard this. Airbnb,
yep.
I've heard this story that someone noticed there were programming books on a bookshelf in Airbnb and contacted them that way. How far is too far in this? That's too far. I think so too. That wasn't me. So when we start to feel icky, that's too far.
Right.
But where does GDPR sit
the creepiness factor, and yeah, I think those are things you have to ask yourself. The circumstances are going to be very important.
Yeah.
The exact circumstances. But so just to the public data, yes, but. And there are these requirements, right? If you get information from a third source within the month, you have to give notice. And what's your legal basis? And how long are you keeping the data? And are you letting people object, or are you actually going to rely on consent? And why you would do that.
Interesting.
So I'm going to move on. So the right to object. Sure.
We have a question. Sorry.
Okay, so I have a specific scenario here.
Okay.
So as a recruiter, let's say you find a candidate on LinkedIn, then you add him or her to Workable, which then Workable does its thing in the background where it scrapes for like phone number and email address, and then those remain in your database. You contact said candidate through LinkedIn, they don't know you have their phone number, which might be taken from Facebook or whatever they find it. You don't actually know where they take it from. And you reach out to them through LinkedIn and you tell them about the job, and then they never ever reply to you. Within a month, you're required to send another email or contact them through LinkedIn and tell them, we actually have this information on you. Can we keep it or not? Or how does it work specifically?
Yeah, you should. I think you should probably to start, may I say, cleaning up, for example, legacy data. Think about, as soon as possible, at least as from May 25, providing the notice that's required under GDPR, and doing that, and then being clear about, obviously in the notice, what you're doing with the data and how long you would like to keep the data for. This is something we don't know if is going to change under GDPR. But today, the approaches of the different countries are so different as to how long you can keep, let's say, rejected candidate data. All right? So you go from an extreme, as my Dutch colleagues tell me. In the Netherlands, you're only supposed to keep a rejected job candidate's data 4 weeks, unless you have consent, in which case you can keep it 12 months. In France, the regulator has said, if you notify people that you'd like to keep their data, they don't object, you can keep it 2 years, up to 2 years. And if you get consent, you can keep it as long as they consent to. Of course, they can always withdraw consent. So maybe this will all even out under GDPR, although again, there are these exceptions for employee data processing. So it's not so clear. I would think, and it's similar to what we see in the marketing world, you have a lot of leads, you have a lot of candidates, potential candidates. Start thinking about, how it is you clean up that database. If you have, it goes back to the data quality issue. If it's older, maybe you really can and should. If you have if you have 3 data elements on a person, maybe you'd want to tell them about all 3 and not just one. And then you have to think, oh wow, and I didn't tell them. Can I call them because I have their, their phone number, and I never told them I have their phone number. So now's the time to start thinking about that.
I think the point on Workable there, I will just let you into the magic. That is publicly available data. It's peek behind the curtain there. So we're not doing anything that's too scary or anything like that behind the scenes. It's compiling that data and making it easier for you to get to. I think, as Carol said, you have to decide whether that is relevant data. So if you are a programmer candidate and you're looking at his GitHub publicly available profile, absolutely relevant. If you're going through his Instagram and commenting on his cats, maybe less so.
Agreed. So we're actually starting around.
Sorry, can I?
Oh, sure.
David Mellon from Bedrock HR. I'm just thinking we keep next of kin details on our HR system for clients, and we've never had any interaction at all with those people. Obviously, we need that detail because something could happen and we need to contact someone. What permission should we seek in those circumstances?
Well, again, do you need consent? That's one of the first questions. I mean, why do you say you need it? Why do you need it? So, do you need it because
someone dies on the job or something?
There's a legal obligation. Do you need it because people are beneficiaries under a policy? A lot of times there will be a justification that doesn't revolve around consent or getting people.
An accident happens at work.
Yeah, and I'd say that's completely legitimate, right?
Bob's
Presumably
dead, we're not telling anyone. It's not good. It's not a good stance. GDPR, just bury him.
Presumably you've asked for the...
We won't know.
That's the real meaning of GDPR, right?
Yeah, right there. Under the rug.
Thanks for covering that. No, there's obviously a legitimate interest for keeping, and presumably you've obtained it from the individual.
Yeah.
A lot of times the question is, does the next of kin or the beneficiary actually know that you have his or her data? And the answer is no, and so you tell your employee, oh, by the way, you're responsible for sharing the employee data protection notice with your next of kin. No, so that's not an issue. If you're talking about recruitment, that could be an issue. Obviously, why do you have next of kin information? About
just going through next of kin. Is your next of kin a programmer by any chance? Yeah, no.
Can we move on, or
We have one more question. Sorry, Whitney.
It's fine.
Making you run.
Hi, Dan Bailey from InfoSum. Another practical example is where you sourcing candidates through third-party recruiters. Can they pass on the consent? Do you need to? So if I get a candidate in from a recruiter and we look at their CV, a couple of things. First of all, we might not want to contact them, but we might want to keep them on file for other purposes. And then we've got the whole thing about our terms and conditions with our recruiters that says, if they send us a CV and that person later applies for a role within 12 months or something like that, we then have to, still credit them for that. But that might be another, a job that you put live 9 months later. So there are lots of reasons why we might we need to keep hold of those details. So do we need to contact all of the candidates ourselves directly, or can we ask our recruiters to give them a copy of our recruitment data processing notice or whatever?
I would look very carefully at the contract with the recruitment firm to understand what it is, on what basis they're collecting the data and what they're telling the candidates. It could be that the information they're providing is sufficient to allow you to hold on to the data. In my view, it's likely that a lot of those contracts should really be, revised to account for GDPR and understanding the exact terms under which, you can keep data and of course how it's being collected in the first place. So right to object. Excuse me, right to object. So the right to object applies when you're processing personal data based on legitimate interests. So legitimate interest is a great legal basis. It's more flexible. We say right now it's kind of the kitchen sink for processing a lot of times in the HR context, is because legitimate interest is like, well, we have a lot of legitimate interest. But it does give rise to this right to object. And once a candidate or an employee objects, this is where you'd have to demonstrate compelling overriding legitimate grounds to continue processing the data. The regulators have given some examples of this. One of the examples they give, I think, is in case of a pandemic. That would be a
zombie apocalypse.
Yeah, exactly. So, but these are the kinds of issues where we just don't know yet how far the regulators are going to push this idea of compelling legitimate grounds. Are we have to keep your data because to save the world, or whether there's a lower standard there. And we find again the establishment, exercise, or defense of legal claims as an exception to continue to process personal data on the grounds of legitimate interest. And then this may be relevant for some of you. There's the right to object when you're processing data for marketing purposes. This is an absolute, right? There's one rule in GDPR, it's like the right to be free from receiving direct marketing. So keep this in mind if sometimes your recruitment activities kind of blur over to the area of marketing. Not the same thing. And there is this absolute right. I think we'll go on to portability. Portability is a brand new right. And what it means is that the individual has the right to obtain his or her data in a structured, commonly used, machine-readable format. The idea being that the individual can then take the data, let's say your recruitment firm. They can take all your recruitment files on the individual and then give them to your competitor. That's the idea. It's to promote competition. Originally, I don't think they were targeting recruitment firms, but more, Facebook or whatever. Geez, I'm sick of Facebook, and now I want to move to another social media site. And how do I get all my photos moved to the other social media site? And the individual can demand that actually all the data be transferred directly to the competitor. So, not that we're anticipating, a rush of demands to recruitment firms say, okay, now I want you to, transfer all my personal data to your competitor. But this does exist. So, and the exception being that the portability right can adversely affect the rights of others. So, for example, a typical recruitment file, right? It's not as if you only have the name of the candidate. You also have the names of, hiring managers and others who have opined on the candidate's suitability and all that. So that raises the issue as well. Can we, share that name? And probably you shouldn't. Probably you should be redacting, and you should be redacting maybe not only names, but titles and whatever, any indirect identifier of the individual. So that's a brand new right, which may or may not be relevant. I think it's maybe too early to know whether or not people are going to start exercising this right to get their recruitment files moved from one firm to another. But that was the purpose behind it, to facilitate competition. And so the next right relates to ADM, automated individual decision making. This is a right not to be subject to automated individual decision making, including profiling. So basically what this means is if you're processing personal data, taking a decision on the basis of that processing without any human intervention, and there's going to be a legal effect for the individual or similar significant effects for the individual has a right not to be subject to this processing. So you can think of, let's say, tools that automatically filter candidates for a position and spits out the rejection list and says, we're not going to consider these people for this position, and there's no human oversight. Yep. That arguably, because these are the early days, would fall under this right not to be subject. The regulators have come out in their guidelines, they're not final, have said, in fact, this is not a right to be subject, not a right not to be subject. This is a prohibition. Okay, this is what this is their interpretation of right not to be subject. Prohibition. No automated individual decision making, except consent. There's some other exceptions too, but they really talk about consent, that you need consent. And you need explicit consent to do this. Now, again, this only applies if the decision making is without any human intervention. The human intervention has to be meaningful. So I'm not going to pretend that I have any answers here, because the potential implications of this are, I think, pretty far-reaching, especially because we're seeing more and more automated decision-making in all areas of business, and not just recruitment. So something to keep an eye on. The final guidelines should be coming out next, well, hopefully by May 25, on this issue.
I think we've got to recommendation levels, but we haven't got to this person's getting hired and the machine says so, and then they turn up the next day. So is that intervention of that okay, you've recommended some candidates to me, and I'm going to make my selection from those recommendations.
Right.
Okay.
Right. But there are many systems, we see many systems where, they're actually
certainly
not a
it's promised.
Human intervention. Well, if you have, whatever the reason may be, 10,000 people to sort through, and how far does this have to, logically, if you've got an opening for a programmer, and you have an application from an accountant, if you're filtering that,
I don't need to make that decision.
well, is there really a significant effect or a legal effect? Because the accountant could never get the job anyway. I think you have to try to be reasonable about this, because there are a lot of automated tools, or there will be automated tools, that will be really helpful to these decision-making processes. And the corollary of that is profiling, right? These draft guidelines have gone so far as when you sort your employees by gender and birth date, that could be considered profiling. So we're fun times ahead as we follow all this. And just to finish off, we don't want to forget the other rights. The right of access, I'm sure everybody in the room knows this right backwards and forwards, because it already exists. Conventional wisdom is that this is exercised more often in the UK than anywhere else. The right of access, the right to access, get a copy of one's own personal data. The right to rectification, correction, this already exists. So I can correct my data. I have a right to do that. New right is the right to restriction. So restriction basically means I have the right to have you stop processing my personal data except to store it, which might imply that you're tagging the data so that it doesn't get processed in the interim. And why? Why do you have to restrict the processing? One reason is because the accuracy of data is contested by an employee or a candidate. So usually where these situations get complicated is, geez, I had a job interview, especially in an internal, I had a job interview and I wasn't offered the job. And actually I think that there were some inaccuracies in the record relating what I said in the interview, and you can have these types of situations. Another case where you might have to restrict the processing is if you want to delete the data, but the employee or candidate says, no, I need the data to establish a legal claim. And that might be because there's a dispute as to hiring or promotion, right? So really, and then objection to processing based on legitimate interest. That we talked about, somebody says, oh, well, my rights override your rights to process on the basis of legitimate interest, and then you have to come back and demonstrate your compelling legitimate grounds. While you're discussing, whose rights should prevail, the individual can ask that the data be restricted and no longer processed. So, if there's one takeaway from all these different rights is that they are different rights, and they each has very different conditions for exercising, and you really need to look case by case. Sometimes you'll get a slam dunk case of, wow, person asked, exercise this right, it's very obvious, do it, be done. You have 1 month to take action. Under GDPR, it can be extended to 3 months. In other cases, it's going to be very, very difficult, right? You might be looking at imminent, legal claims against your organization when you get one of these requests, and so
do it quickly.
Well, make the analysis quickly so that you have, the best argument possible for, let's say, keeping data or deleting it or correcting it or not correcting it. So any questions?
We're actually going to take a question from some of our live stream.
So the first question we have here says, does the GDPR also apply when you're building talent pools? So building up a database of new candidates.
Yeah, absolutely. Absolutely. Applies to processing of personal data. So, processing has an extremely broad definition. Technically, a screenshot of a social media page, saving that's processing personal data. So.
And we actually have a second question that goes along with social media. We've had a lot coming in about social media in general, and especially LinkedIn, and how contacting potential candidates on those platforms or looking at their information on those platforms complies with GDPR.
Right. So going back to what I said earlier, and I don't know the exact terms of use or the privacy policy on LinkedIn, but in the case I cited earlier, one of the concerns was that people have put their information on a social media site for a specific purpose, and now it's being used for a different purpose, and therefore that may be excessive use of that data. There are potentially a lot of issues, right? As I said, there's so many conditions to lawfully processing personal data. And one of them is, excessive processing, so you're collecting more data than you need. But the other is, and is it relevant? But also, was notice given to the person at the time they disclosed the data, what it would be used for? And in the case in question I'm talking about, there were like 8 or 9 different social media sites concerned, and the regulator went so far as to look at the privacy notice of each of them to say, and now this was a few years ago, so Facebook privacy policy has changed quite a bit since then. Yeah. But they said, the Facebook privacy policy at the time said, this is public information, et cetera, but not specific enough. And it wasn't specific enough that your data would actually show up in the hands of, a third party in a different sector. So unfortunately, I think the broad answer to that question is, well, you have to get a little bit granular and look. My expectation that it would have to be verified is that, on LinkedIn, there's a better chance there's been adequate notice, and if there hasn't, then the idea of notifying the person within a month of collecting their data is really key, and giving them the right to object to the processing, or if maybe in a certain jurisdiction you might feel, well, actually we're going to get consent here, as even though there's so many drawbacks with consent.
And the purpose of the social media site in question has to come into it, right?
Absolutely.
So that's LinkedIn.
Right,
you don't
exactly.
just join up to...
It is a professional, yeah. And the 2017 pronouncement from the EU Data Protection authorities says as much, you know what I mean? Whereas going on a professional site could very well be justified, private life information less so. And is that, in any case, is the information relevant to the position? So to your point about the cats or what have you.
Yeah. No one joins LinkedIn just to see that recruiter's gym updates.
Right.
But if you're there for a reason. Cool.
Hi again. So you talked about the fact that if, let's say, the job applicants are not necessarily relevant, you're not looking to pursue that specific application, you should delete it just to be safe, on the safe side. So I just want to ask you, a lot of companies have this agenda right now about gender and ethnical diversity, which spans over, let's say, 2 years. So you need you start a campaign right now about, having more women in technology, for instance, and then you kind of see at the end of the year how many applicants you've had, how many of those got into like different stages of the selection process, but you need this data. Is this like a compelling enough reason for you to kind of justify the fact that you've been keeping this data? Especially since probably, let's say if you have a recruiter in the organization, their performance, like yearly bonus, is directly to one of the indicators is bringing more diversity into the business.
Right, so there again, you may in fact have the right, you may legitimately, lawfully keep certain data. It really is going to depend, and this is where it gets meticulous, right? It's like, oh geez, in what conditions did we gather these applicants' data, and how long did we say we were going to keep the data? And then you throw in the fact that in some jurisdictions you might be looking at consent to keep it for a longer period, but in others just giving them the right to object. And again, I would stress that I wouldn't expect anyone to have a database or a talent pool that's 100% clean. Right? There's going to be some older data in there, or incorrect, or or there was not adequate notice given, or what have you. I think the time to start is now, and to be really clear about the fact that you want to keep the data and how long you want to keep it, and at a minimum, informing people and saying, oh, by the way, and if you object, of course, we can and will delete it. And maybe in some circumstances, you're even going to ask for their consent to keep it for a certain period of time, trying to harmonize that period if it's possible. Like I said, right now, technically, if you want to be compliant, you can't actually apply the same retention period across all of Europe. Just because of the difference in the national approaches. But really the time is now. It's justified. I mean, you could try to say, well, it's actually legitimate interest to keep it for a longer period of time, but we do have these numerous opinions from the data protection authorities about how long you're supposed to be keeping candidate data. So
I guess the longer, the less legitimate, right?
And the longer, the less legitimate. And we do see, so in Germany, for example, up to 3 years, potentially, depending on the circumstances. In France, up to 2 years, but with the right to object. Contrast that with the Netherlands, 4 weeks and 12 months with consent. So again, that may change, and that's not to say that diversity is not legitimate. Although, in some cases, depending on the legislation, taking that into account could pose problems in and of itself, right? So this is where really the data protection law ties back to employment law, and what's permissible in one jurisdiction. So for example, diversity data in the UK, that's illegal in France. There's some openings now to collecting that data and whatever, but historically that's been illegal. So it's very different markets. And so you really need to keep in mind the employment law implications as well as the data protection.
We'll take another from online.
You're way late.
So the next online question is in relation to RTBF. If you delete a candidate from your database, is it possible that the same candidate will end up in your database again later? Yeah. And this seems like it would be a problem because you'd have no record of them having already applied and been,
No, that's right. And so the only logical conclusion, I don't know that there's been a regular pronouncement on this, is that in fact you have to keep the data in order to put them on a list of data you're not supposed to have.
So remember them to forget them.
Well, this is the issue with marketing. It comes up all the time.
If I forget them, I won't know the next time they apply, right?
Absolutely. No, it's a bigger issue, obviously, with marketing because you might get a refresh, every 90 days on your lead. That means somebody who asked to be unsubscribed, taken off a list, is getting a new marketing message every 90 days. So you can, do the analogy with candidates. And the irony here is, okay, so you're supposed to delete their data. At the same time, you're lawfully reobtaining the data, contacting them. If they start getting messages every 90 days, the risk of a complaint to the authority has just skyrocketed. Because if that's something, we see far more problems, obviously, around marketing than around recruitment in practice. But if there's one thing that will really anger people, it's
getting that message again,
unsubscribing or take me off your list, and then guess what? 3 months later, and then 3 months after that. And that's when they will file a complaint. and it only takes one person to have a visit from an authority.
I'm conscious of your time.
Yeah, and
we've
so
gone on quite
we've gone
long.
a little bit,
We're
and we
gonna
haven't
go
even
on
got to Brexit.
We'll go to my favourite subject now, Brexit.
Are you gonna take over?
No,
Is this your slide?
I just love Brexit.
About Brexit. All right, so there are a lot of words up there. In short, so the UK is still part of the EU and will be, right, on May 25, pending something really unforeseen happening. So GDPR will apply in the UK. However, Brexit is programmed for March 30th of next year. And as a commission, the European Commission recently reminded us, as of that date, the UK becomes a third country. And that means transfers of personal data from the EU to the UK will need to have a lawful transfer mechanism. Now, the UK government would really like to have the UK considered as a country with adequate protection, which seems obvious if GDPR is being applied in the UK. Now, this is all part of a larger political discussion, and so it's possible that instead of saying, okay, UK, you're kind of like Norway, and therefore transfers to the UK are adequately protected, there will be nothing. And that means that technically, as of March 30 of next year, you would need, for example, EU standard contractual clauses, otherwise known as model clauses, in place to transfer data, say, from your Milan office to your London office. And of course, nobody has papered that for the obvious reason that the UK today is part of the EU. So there could be a gap if the adequacy decision does not come down as part of the trade negotiations going on around Brexit, this period of time when you're actually supposed to paper the transfers made from the EU to the UK.
Wow.
That's as far as I'm going to go on Brexit.
Should we have one Brexit question?
That's it.
So, Peter Ward, PodPoint. Sorry, just to clarify, does that mean that, because at the moment the data is held within the EU, and then post-Brexit in the UK, the data will not be held within the EU, does that mean you have to go through your whole database, even though the data is not changing country, that we have to send out to our own database and say, hey, sorry, do you consent to your data now being kept within the UK rather than the EU?
Generally speaking, you're not going to be asking for consent.
Oh, sorry, yeah.
Consent to transfers. Getting consent to transfers. I mean, today, you can transfer data outside of the EEA or the EU based upon consent. It's usually not a good idea. It's really only for a one-off transfer. So, that wouldn't change. I mean, the irony here is that the law we expect in the UK will be exactly the same as it is today, will be GDPR, and yet there will be this issue of transfers. So normally speaking, either you already have an intra-group agreement, so let's say you're sharing information within your group of companies, and you can extend that to the UK, or maybe you've got binding corporate rules in place. They're still relatively uncommon. More and more companies are adopting them. So there are other options, but generally speaking, you're not going to be asking for consent. And the fact that data is located obviously in a database in the UK, yeah, that means it's been transferred to the UK. But again, I would really advise in almost all cases not to rely on consent to, which is good news, right? Because the last thing you want to do is go out and ask the 50,000 people in the talent pool to consent to a transfer of data.
Thanks,
to
Brexit.
the UK, yeah.
Right, I think we've overrun. I've taken my watch off and I'm looking at my wrist. I think we have overrun quite a lot. Thank you all for coming. Thanks to Carol for making that a little less thorny a topic. Still lots to think about, I think. For those in the room, you have these two documents, which details Workable's approach and also the working towards GDPR compliance for your businesses. Do take them, have a read. For those on the live stream, I think the links are going to be in this live stream as well, so you can click those and download those. Any questions that you had on the live stream as well, they will be answered by Workable's GDPR team, and we'll be producing a lot more information for you. I know this is going to be something that we're thinking more and more about, even though we've had since 2009 to be thinking about it. Oh well, ever prepared. So thanks again to Carol. And for the people in the room, there is coffee and dessert. Sorry, live stream, no coffee and dessert for you. But thanks, Carol.
Okay.